Okay.
We are good.
Okay, the time is now 1 o'clock on March 27th. The chair hereby calls to order the meeting of the Kansas Governmental Ethics Commission. Welcome commissioners and staff, and welcome new commissioners. In your materials, you have today's agenda, and you have the minutes from our meeting on January 24th and our special meeting on March 7th. Before we begin the meeting, can I obtain a motion to approve the agenda and minutes as written, unless anyone can identify any corrections that need to be made to either? Anybody spotting any corrections?
I'll move to be approved as written, Mr. Chairman.
Thank you, John. Do I have a second?
I'll second.
Thank you, Patty. Any additional discussion? Hearing none, all in favor of approving the agenda and minutes as written signify by saying aye.
Aye.
All opposed say nay. The motion passes. Turning to the agenda, we'd like to recognize the two new commission members we have joining us today, Mr. Earl Gray and Mr. Bo Jackson. Mark, if you think it's appropriate, maybe we go around the table.
Delicious tea. It's a delicious
Have everyone introduce themselves.
Yes, I think that'd be great. Would you like to start as chair, or do you want to go last?
Let's do everybody there in the room first.
Okay. Let's start. You want to start down there, Mr. Helmer? We'll go around this way.
You lucky day.
Mr. Gray, I'm impressed by the welcome aboard, Earl.
Thank you.
How did you get the names to match so well like that?
Yeah, we'll just do.
Homer, I'm from Salina, Kansas, and been on commission for 12 years, Mark, something like that.
I think so.
I'm truly one of the apostles, but welcome aboard. Retired as a district judge to criminal mediation and mediations at this point, and good children, 7 grandchildren, and do my best to say I'm sorry when I went the last word with my wife, and otherwise, welcome aboard. Bo, good to meet you.
Likewise.
I'll take some hitting lessons after.
Happy to provide the service.
I'm Caitlin Bull-Stewart. I'm the general counsel. I've been the general counsel here since last June, so coming up on a year. So I'm still pretty fresh, just like you all are as well. So I will continue to learn with you, and we will I think even those that have been here for a very long time, I think you learn something new every time we meet probably. So it'll be exciting, and we're excited to have you both.
You both heard a lot from me already, but Mark Skogland's been the director since 2017, and before that I was doing nonpartisan work for the legislature at the Kansas Legislative Research Department.
Chris Berger. I'm a lawyer out of Lawrence and came here a little over a year ago. Just still getting my feet under me.
John Stolbuck. I'm also a lawyer in Lawrence. We've had cases together, believe it or not.
Sure.
Depositions that he did on can't remember the guy's name. But he was,
That was good. That was very good.
He was he did a good job in the deposition. By the way. My client was kind of off to the side. I've been on the commission for 20 years or so. I was appointed by the minority leader in the Senate. I served in the Marines for 3 years before I went to law school and served in Vietnam. And I served in the legislature for 14 years. I chaired the Judiciary Committee the last 2 years that I was there. And I have 2 grown sons. One lives in Shawnee County, one lives in Douglas County. And we have a small farm west of Lawrence. My wife was retired. She worked for Miniger for many years, and then for the Johnson & Johnson Company. And I work on the farm in the morning and go into the law office in the afternoon. I try to take cases that don't require me to go to court, but it doesn't always work out that way. Welcome to the commission.
Thank you.
I'm Patty Dingler from Wichita. I'm a retired attorney. I've been here since.
Jay Rodriguez, I'm an assistant attorney general. I serve as conflict counsel of court.
My name is Paige Quinton Paget. you all have also worked with me a little bit. I've been with the commission since I've worked for the commission since September of 2022, started as the pack and party coordinator, and then almost a year now. My first day as office manager was April 3rd of 2023. So I've been in this position for almost exactly a year.
Do I go?
Mhm.
Okay, it's gonna be. Hi, everybody. Bo Jackson is my first meeting, as you know, originally from Andover. I'm a partner at Hush Blackwell and Kansas City office, practice international trade and IP litigation.
Hi, my name is Earl Glenn. I'm originally from Wamego. I went to K-State, graduated with degrees in engineering and computer science. Went off to DC for 4 years as a federal, working on classified projects back there. Returned to Kansas City, worked on pharmaceuticals, medical devices, life science research, and recently medical science research at a hospital in Kansas City. I have a wife, 2 kids, and 2 grandkids, and a dog.
When were you at K-State?
Well, that's a long story. I was there from 71 till 82.
Okay,
I did graduate in 4 years, but I worked a long time getting a 2-year master's.
I see. I was there I graduated in 73. So
We overlapped a little bit.
Yeah. Commissioner Schonifer?
Yes, my name is Mark Schoenhoff. I'm an attorney out of Wichita. I've been practicing here for about 31 years now. Very new member on the commission. I too am married with 2 children and 2 grandchildren. Look forward to working with you.
And for myself, I'm Nick Hale. I'm general counsel for a craft brewery here in Kansas City, Missouri. I live in Fairway, Kansas. I'm originally from Wichita, married with 3 kids. And I've surprisingly been on the commission for coming up on 5 years now. So time flies and goes fast. But Earl and Bo, it's very nice to have you both join the commission. So we got a big agenda, so we're going to get after it. Mark, unless you had any other comments?
Nope, not at all.
Okay. Well, the first item on the agenda is we have an opinion to review and discuss. Caitlin, Mark?
Yeah, so we received this request this is the first request for an advisory opinion that I've had in my tenure here. This concerns a campaign donation processing platform that's called Democracy Engine, LLC, or Democracy Engine colloquially. And this platform is, as opposed to other platforms that you all might be familiar with, such as, if you are, like WinRed or Act Blue, this platform, as opposed to candidate focus, it focuses on the donors. So it posits itself as a kind of a one-stop shop or a place to engage in what it refers to as complex donation processing. So an individual can go to this website and donate to PACs, candidates of different levels, federal, state, all candidates all over the place, and they just have to go to this one website. So the opinion request arose because candidates were receiving checks from this website, but the checks do not state who the donor was when originally receiving the checks. Instead, the check states Democracy Engine LLC, I have the exact transfer account. So it indicates that they are not the original contributor of the funds, but along with that check, candidates would also be receiving instructions on how to create a login to use Democracy Engine to access the data and the information for the actual contributor to their campaign. And so the question arose from candidates of, can we even accept these contributions? And all the questions are laid out of how do they accurately report these contributions, and can they accept them during session, because this has primarily impacted legislators. So as we dug into the matter, I did research on Democracy Engine's website, looked at other jurisdictions, and the answers to the questions is that generally, yes, they can accept those contributions if the candidate first creates a login on the website, to access the data file showing who the actual contributor of the funds were. Because KSA 254154 sub B does not allow for anonymous contributions over $10. So the candidate has to know who the contribution is coming from before they can accept that contribution, or there would be a risk of violating 254154B. The candidate also could choose to just not accept the contribution for Democracy Engine. That's their choice. But if they want to accept the contribution over $10, they must first create the login. The same type of idea applied to candidates accepting those contributions during session, which is the candidate has to create the login to identify if the person, as defined under the Campaign Finance Act, that is contributing to the candidate is an individual who is not a lobbyist. Because KSA 254143A prohibits members of the legislature or candidates for the legislature from accepting contributions from January 1st through adjournment sine die from a non-individual or from a lobbyist. So they have to obviously know the identity before they can determine whether or not it is an individual contributing and can accept it. And then finally, the last question was, how should these things be reported? And reviewing other jurisdictions, the candidate would report once they gather the information of who actually made the contribution, the candidate would report that individual as being the contributor. And then once they get access to the back end of things, when they log in, they can look at that data file. They should be able to see what amount of that contribution went to a processing fee for the website. And once they see the processing fee, the candidate lists the entirety of the contribution, and then the processing fee is listed as an expenditure for the campaign. This is consistent with how other jurisdictions have reported contributions from Democracy Engine itself, and is now, if they do it this way of getting the information first, they would not run afoul of the Campaign Finance Act. Unless Mark had something to add, I am open for questions if anyone has questions or changes to the draft opinion.
Do we know what WinRed and Act Blue do? I mean, those things seem to be coming through now without any problem. So why is it a problem for this group?
So WinRed and Act Blue, it's because they're candidate focused. So the candidate creates a login and opts in to use Act Blue and WinRed. Whereas Democracy Engine, these are unsolicited checks. The candidates don't create a login or subscribe or anything. The donors just pick candidates that are, announced on Secretary of State's website or whatever. And then the candidates have to take the next step to create that login. But Act Blue and WinRed, the candidates already have access to that information by opting in.
Can I add to that too?
Yes, please.
Part of that too is the reason this matters is that Act Blue and WinRed and other payment processors that are set up by candidates, when someone makes a donation, their name is already associated with that contribution when it's received by the candidate. Democracy Engine, it's not. Democracy Engine, the check is received by the candidate and they don't know yet who has provided it. The check is from Democracy Engine transfer account. Democracy Engine is indicating that it's from someone else. They're just not telling them who it is yet. So that's why these are different platforms and why we've had a lot of questions, frankly, about Democracy Engine in the last couple of weeks.
But on the FEC level, they report, both WinRed and Act Blue, they report all the contributions and then they're earmarks to the candidate. It seems like this other organization, I work the same way.
Yeah, they're just set up very differently, it appears.
Yeah.
So is it like an aggregator? Like it just, okay.
Yeah, they could contribute by using that website. They can contribute to nonprofits, to charities, to different causes, and also contribute to candidates. And it's like it posits itself as it's using the language of complex donation processing, just so you can go once. You don't have to go to each individual candidate's website to contribute. It's just supposed to make it easier on the donors.
And it's interesting you said they'll kick out donations to candidates without the candidates even asking for them.
Correct.
Which is, I would think, pretty unique.
Yeah, it's
A candidate just all of a sudden gets a check from Democracy Engine.
And had no idea that it was coming. They just received that. Yes.
But for example, if Sue Smith wants to give a contribution of 100 to candidate A, and then Sharon Jones wants to give it to candidate A also, does Democracy Engine send one check for both of those contributions, or is it a check per contribution?
That was not entirely clear to me without creating a login. That's why it's important for them to create that login first to get to see that breakdown. We didn't have any of the candidates that they were waiting on our decision to see whether or not they should create that login. So without seeing the back end of things, I can't tell that breakdown. But based on what I was reviewing from other jurisdictions, it appears to be one donor at a time. But I don't want to for sure say that without seeing the back end of things.
Yeah, I jumped on the website this morning and there's no access to it. There's no way to know how it functions. There's no way to know if it's candidate or issue or solicited or anything about the manner in which donations are made, how they're put together. It's just a black box that suddenly a check pops out of.
So when they go to that login and they look at that back end, are they gonna get enough information if it's like a $500 contribution to know the occupation of?
The website did state that information would be included because they had some semblance of, the website seemed to understand some compliance with campaign finance in regards to the occupation, the name. Yeah, I believe it's the donor's employer, address, and occupation would be available through the data file.
For all amounts, or, I mean, Act Blue reports $1 and they put, all that information for $1.
As far as I could tell, based again on the information that was available, it's all donations.
So they would have enough information from that online portal to fill out everything we need for the report.
And if it was under $10, that would not be an issue anyway, right? Because
then it doesn't matter.
As long as the aggregate amount that they receive anonymously does not exceed half of what one contributor could give, since there's the aggregate anonymous limits.
It sure seems like they should get that information with the check though.
I agree with you wholeheartedly that I think that they could design their processes to be much better than they are.
Were you able to get any information on how the donations are solicited, the contributions are solicited, and how they're organized on the website itself?
I didn't really see that I know that the website has done advertising. I don't see that they necessarily reach out to specific people to solicit contributions. I didn't find anything.
The questions we have fielded from legislators indicate that they did not solicit these contributions.
Yes.
But that's all we know.
I understand they didn't solicit them.
Right.
But I'm just curious, since, we have issues of individual, I don't know, it makes me uncomfortable not knowing the manner in which this money gets put together.
It is very odd. I think that all of a sudden, a lot of people in Kansas are getting Democracy Engine checks when previously this isn't something that we've ever had before us, which is part of why I don't want to speak for you, but I think this is part of why we tried to have the questions focused on, if you're going to accept these checks, what do you need to make sure that you do to make sure that you're in compliance as a candidate?
But the opinion itself, though, is written specifically authorizing Democracy Now, as opposed to it as just a conceptual portal.
They've been around since 2009, I want to say. Been around for a while. It's just that we haven't seen it in Kansas.
The opinion is specific to Democracy Engine LLC.
Yeah.
The synopsis I can amend if we need to, because I just make the statement of third-party payment processor must attribute the contribution to the person who made such contribution. I can amend that to make it specific to Democracy Engine.
Or we can amend it
to should be specific. I don't think we know
Okay.
anything about
I
that,
see what you're saying.
or how they organize or how they collect. And I don't even know what the repercussion of a generic approval platform that is a black box.
So I think the solution to this, tell me if you think I'm wrong, it would be every time it says Democracy Engine, refer a generic payment processor and say a payment processor that does not at the fore provide the campaign information with the check. And then we're not saying anything about Democracy Engine. We're talking about the very specific question that was asked by the legislators.
So then the approval then that you'd be seeking to this opinion is that anyone who basically aggregates. So if you can look through what their initial check is and determine who those individual donors are, that'll be acceptable.
Right. As long as it's being attributed properly.
at least through inquiry.
Yes. That would be that's really the opinion.
Yeah, how might we require them to fill out something like a verified statement where you find out everything that they've given to anybody so you can do a cross check? Because right now you can't do a cross check on it at all.
Right. Well, ActBlue and WinRed are other payment processors aren't required to do that in Kansas.
Well, that's what the feds do, but we
Right.
need to do what the feds are doing. So.
Right. That would be a statutory change.
Yeah.
Am I
Any
correct?
question?
Go ahead. Is that Mark?
No, I was gonna, well, one thing, Mark, are you wanting an action of the commission to ultimately approve either the version of the opinion or with some amendments? What are we wanting here?
There are three options, really. I mean, there are four of them. We can approve the opinion as written, maybe 100. That we can approve the opinion as written. We can approve it with the conceptual amendment that Democracy Engine's name is removed and replaced with a generic third-party processor and describe the situation, and the commission could approve it in conceptual form. Third, we could redraft and bring back to the commission at the next month's meeting in April with that change, so you can see the text and it's not just being approved in conceptual form, or it could be outright rejected. The commission could simply vote against this opinion with instruction on how to redraft a different opinion response. Those are the four big paths. I don't think the fourth one probably works since I don't think that anyone has any issues statutorily with the interpretation. It's just how it's described. At least that's how I'm hearing the discussion in the room.
Yeah.
Good
Well,
things
what were you
moving.
getting ready to say?
Excuse me?
Commissioner Jackson. I think.
Oh, go ahead.
Good things moving. I'll move that we approve the opinion with the conceptual amendment of making Democracy Engine generic.
Can I
Thank you,
propose a motion?
John.
We need to discuss that one first.
I think it's open for discussion if it's seconded, but it hasn't been seconded yet.
Oh, did you have, or Commissioner Jackson, did you have a question?
Mr. Chairman, I think that it would die for lack of a second
Okay,
first before a discussion would be opened on it.
well, let's make sure we touch on all relevant points. So let's just call the motion dead for the moment. Do other commissioners have additional questions or additional comments?
I think my question's kind of moot in light of executive director's comments. I would move that we consider the third option that you proposed.
To redraft and revisit at the April meeting with the discussion about essentially don't refer to Democracy Engine specifically, but to a generic processor that does these things that we're specifically talking about.
Yeah.
So it can't be misinterpreted as us providing any approval to anything else Democracy Engine does.
That's right. And then we come back and discuss it.
I'll second that motion.
Mr. Scoglin, I think Mr. Nye may have a comment from the public before we.
That's up to the chairman. Mr. Chairman,
Oh, sorry.
if you would like public comment, Mr. Nye appears to be seeking comment.
Yeah, absolutely. Mr. Nye, you have the floor.
Thank you. And I, just so you know, I emailed and asked for public comment. I know it wasn't included on the initial agenda, but I got this advisory opinion yesterday and initially was, kind of dismissed it as a contribution issue. There are previous opinions that the commission has discussing these ideas of conduit contribution. 93-41 is a previous opinion that discusses Emily's lists and bundling. But there's kind of an overarching concern I have, especially since this is referring to 4154, which is the contribution in the name of another statute. There's this only discusses B, which has to do with disclosing the name of an individual. It does not at any point discuss 4154 subsection A, which I just want to remind you what that says, which is the general prohibition. It says, no person shall make a contribution in the name of another person, and no person shall knowingly accept a contribution made by one person in the name of another. And so Obviously, this has been the source of much consternation in the legislature, in the courts. There's a pending Court of Appeals case that's going to be set for oral argument, looking at the agency's novel interpretation of this as applied to activity that happened in 2020.
Mr. Chairman, this is no longer about the opinion. This is just grandstanding about his litigation strategy.
Well, Mr. Nye, I appreciate your thoughts and your input. I will allow you to finish your thought, but try to be as concise as possible because we have a large agenda today. So go ahead and finish your thought.
My point is, without an earmarking regulation, without any clarification as to the broad language, how does this activity not fall under that as well? And so I think that the commission should be convinced that it understands all the interactions of this particular statute before it moves forward. I would encourage the commission to request of its staff any court pleadings, any transcripts of court pleadings over the past 2 to 3 years that discuss interpretations that the public may or may not have access to, how this is being applied in the enforcement context. And so I think advisory opinions and rules and regs are the way to go, so that I, as a practitioner, know how to advise my clients regarding conduit contributions and PAC contributions. But ultimately, I think it all needs to fit together. So I think you as the commissioners need to be convinced that this does all fit together and that you're not opening up individualized exceptions on a case-by-case basis.
Mr. Chairman, before anyone has any additional comment, this opinion has nothing to do with giving in the name of another. This is a payment processor who is saying that the contribution is from a different entity. They're not claiming that it is from themselves in any way. Mr. Nye represents clients regarding giving in the name of another, and I think that the commission should be cautious in proceeding with open discussion on something where comments could be taken out of context in this matter. Okay. I think we should focus on the opinion, which does not have anything to do with giving in the name of another.
Why isn't it an opportunity to clarify on A?
If we want to issue opinion on giving in the name of another, we can do that, but these are not the facts. These facts have nothing to do with giving in the name of another.
I'm grateful to remain a layman on all of this, because when I see a check that would come through literally in the name of another, certainly creates the appearance to the general public.
It is not being attributed to Democracy Engine.
That's what I was trying to say, is that it literally comes and it says, it does not say from Democracy Engine. It says in the top left-hand corner, Democracy Engine LLC transfer account, and explicitly comes with notification that says, this is from a contributor, you create this login information and you can see the donor who it comes from. So that having all of that together is why they're not saying, it's not just a check that says Democracy Engine LLC to John Doe for Kansas. It has that that additional disclaimer language in there. That's not from them.
Mr. Chairman, we have a motion on the floor and I call for the question.
You're saying you're wanting to resurrect your previous motion. Which one are you saying?
Mr. Jackson made a motion which I seconded. And that was for option 3.
To amend the
staff to redraft and bring it back to us next time.
Yeah, sure. And I guess on that point, before we take a vote, because it has been seconded, is Mark, Caitlin, is it fair to invite commissioners to individually offer other comments or questions offline outside of the meeting, just individually, if there's anything else they wish to share?
I will
Jay,
throw that to conflict counsel from the Attorney General's office.
I'm going to be pretty careful about that we're not basically doing the equivalent of discussing public business through email.
Yeah.
Yeah, well, I was, I guess if there's other comments, I guess in the course of this meeting or otherwise, you have an opportunity, but I expect that we'll see an amended version at our next meeting.
Yes.
Okay.
Absolutely.
Well, then let's go ahead and take a vote on the motion that has been seconded. All in favor signify by saying aye.
Aye.
All opposed say nay. The motion passes. Returning to the agenda, we have a discussion item for appointment of subcommittees for regulation review. Director Skoglund or Caitlin, do you want to speak to this?
I can speak to this. So we've been in discussions about this for a while. This is I think that we're at a point where we are going to review all of our regulations. There are some that need to be new. For example, the recusal regulation that's been drafted that we're going to talk about. But I think that all of the regulations under the commission's purview have not been reviewed in quite a while, and it's time for us to do so. There are some that frankly don't apply anymore. There are some that need revision. There are some new regulations that need to be created. It's my recommendation, probably given the broad scope that we have to engage with on this project, that there be 3 subcommittees: a campaign finance subcommittee, a chapter 46, which is our ethics lobbying regulation, that's our ethics and lobbying laws and the regulations that have to deal with that, and then commission procedure. So I think there would be 3 teams or 3 subcommittees that would be reviewing regulations for us to redraft and start sending through the lengthy approval process so we can finally update some of our regulations to current practice.
How would you envision the subcommittees conducting their work, Director Skoglund?
I do think that they would meet as subcommittees, much like we have in other instances. Those subcommittees would go through the regulations, identify issues, things that need to be changed, updated, revoked in many instances as well. I think that it's important that one person, probably the chair, would be my recommendation, to be consistent across the 3 subcommittees to ensure that just a consistency of purpose across the subcommittees. But I think that that would be a good way to start going about it. That creates a bit of burden on staff because it's a lot of subcommittees to handle, but it makes sure that the commissioners dealing with it can focus on the regulations that are specific to a particular area of the law and make consistency across that field as well.
How many members expect each subcommittee to have?
My recommendation is 3 for each subcommittee, but it doesn't have to be that way. The only thing is that it can't be more than 4.
Yeah.
Can I add something real quick?
Yeah, of course.
The only other thing that I wanted to add is that we, as staff, we would prepare, we would be drafting, redlining regulatory changes to present to the subcommittee, not necessarily doing all that work every time that they meet, but so that there's something to review when we do have those meetings, so it's not going in completely cold. So just so there's something else as a reference point.
Director Skoglund, is this something that you would envision subcommittees, let's say that we form them today, having these meetings in the course of the next month, or under what time frame are we envisioning?
Well, we're hoping that we would have a red line draft ready, which we don't quite have ready yet, but I'm hoping that we could have a first meeting before our April meeting, and just so we can have some guidance and procedures, people can see what we're dealing with. I don't think this is a particularly quick process. But I really do want to get regulations moving down the line. In particular, we do have a statutory requirement to create a recusal reg, which we've been working on diligently as well. That's one example of a reg that I would like to make sure we can start moving through the channels of approval.
We did just lose Commissioner Schonifer. They had a power outage. He is rejoining us shortly.
Okay.
So if he wants to be on a subcommittee, he shouldn't be ignored.
Yes, he did just email that yeah, they're having some, so he will be rejoining us shortly, but yes.
Okay. Well,
Ask one of our commissioners.
for myself, well, I'll just say that for however we assemble these and however we conduct this, I obviously want to make economical, efficient use of all the commissioners' time. I think red lines and suggestions would be tremendously helpful. And I think as long as we have a very clear purpose, if you're suggesting that you want me to participate on all 3 subcommittees, I'm happy to do that. And I trust you to randomly, if you wish, Mark, Caitlin, to assemble the subcommittees as you think they make sense?
We can, if you'd like. It's whatever you all see fit. However you all would like to.
Do we have volunteers? Other people who want to be on this subcommittee?
Any particular subcommittee that's
Campaign finance.
What were the 3?
Procedure?
Campaign finance, ethics, which is lobbying, state employee gifts, conflict of interest, and then commission, and then procedure, which is.
Yes.
I'd be interested in procedure.
And Helmer wanted procedures.
Okay. So if we have 3 on if we have 3 on each subcommittee, and if Nick, you're on all of them, then that one would be full, because that would be the chair, Commissioner Judge Helmer, and then Commissioner Berger.
And Commissioner Glenn, you want to campaign finance?
Yeah.
Anyone else want campaign finance? Don't all jump up at once.
Chair gonna be on all 3 subcommittees?
Mhm.
Okay.
Or we could, I mean, I don't want to exclude Commissioner Schonifer, so I'm gonna make sure he has an opportunity if he can return.
Where
Though I
is,
know he's very busy.
have we heard anything from Commissioner Harrison?
He won't be at this meeting, unfortunately. But we could see if he's interested in joining. If we don't have another volunteer, we can just ask someone to join.
Okay,
Volunteer for where you want someone either ethics or finance.
Great.
You can put me on one of those if you'd like.
Okay. Then we would just need one other volunteer if there's someone else who isn't on a committee that wants to be.
What's the committee that needs a spot?
Honestly, if you have any preference between campaign finance and ethics, because we have a spot that it sounds like we've got 3 people who don't have a lot of preference on which one they're on.
I know you were on campaign finance. What were you volunteering for, Patty?
Either of the other 2.
Actually, since this is both of your first meeting, perhaps it'd be best to split you up.
I agree.
Yeah.
I agree.
Yeah.
I'll go to whichever one,
You get the
Patty said she's
the one that I think is has a lot of work, but also the thing we deal with less. So I think it'll be good. The conflict of interest and gifts laws. So I think that'll be good. And then John, Patty, any preference between campaign finance and?
Go wherever you want to put me.
All right, sounds good.
okay. So we have a rough grouping, and I guess that we will plan to meet when we have red lines and draft suggestions in place.
We'll email something out. Yeah, when we have
So does
that.
the recusal run under the ethics then?
I think
Recusal
would be
runs
a
under procedure.
Yeah,
Oh,
so it'd be,
okay.
that'd be yours. Sorry, I think that's still gonna be the one that is the single reg that probably will have the most work is that recusal reg. I think we've got a really good draft, I think, with a lot of great research done on it. But I think there's gonna be a lot of discussion about that one in
Yeah.
particular. So not to sign yourself up for that, but that's what you did.
Director Skoglund, anything else to discuss on this item before we move on?
I don't think so. I think we have adequate guidance from the commission.
Okay. The next item on the agenda are some civil penalty assessments to observe. Mark, do you want to speak to these?
Sure. Pursuant to how we've been dealing with these, there's a large list of candidates. These are usually ones that have maxed out at the January report. The lobbyists also had a February report due as well. You have candidate and treasurers, PACs and party committees, and then lobbyists, civil penalties there. They're all listed out. I can take any questions if you have any. They're automatically assessed by operation of law, so we don't need to actually do anything with them. They're provided for notice to the commission.
So the penalty in Scott Hamlin is different than the one already down the list. Those are 2 different issues.
Correct.
Okay.
The penalty
Any
for
other-
Mr. Hammond for January. of
January
24.
2024.
Okay.
Yes.
Any other questions? If not, we will move on to the item civil penalty waiver requests. Director Skoglund, do you want to lead us through these?
With permission, I'd like to actually move Mr. Scroggins to first because Mr. Scroggins is in attendance personally. With the chair's leave, I think that I'd like to speak to the waiver request form and then give him an opportunity to speak as well since he's actually present today.
Sure, go ahead.
So the request for Mr. Scroggins, he is a registered lobbyist who was assessed $400 in February. He asserts really 3 reasons for a waiver. One is that basically inactivity, that he didn't have any expenditures to report, and he had some issues receiving mail. I will indicate that those 2 are the unique circumstances justification. Those are not typically grounds for good cause. I would encourage a denial on those grounds. However, the 3rd ground is hardship, and you have the financial hardship declaration from Mr. Scroggins. I will not provide guidance on hardship because I think that is ultimately a fact-based inquiry for the commission. So I will not typically provide guidance one way or the other. And just a reminder that the commission can provide a full waiver, a partial waiver, no waiver, and payment plans are also we always can have payment plans available as well. But you have the hardship declaration that I would encourage you to take a look at as well, so that you have everything in front of you. but I would also encourage the commission to hear from Mr. Scroggins as well, who is here.
Yeah, Mr. Scroggins, if you would like to take a minute or two to provide any additional information that you would like the commission to consider, you're welcome to do so now.
Victor pretty much covered it all. Had no idea that I was supposed to do anything. I've been a lobbyist now since 1976. I lobbied papers. But there's no money. I'm new to it, so I'm still trying to navigate to one of the two commissioners just recently on it. So I had no idea, and I didn't know. So I don't think it's fair to assess me for it. I mean, it's up to you guys. Other than that, I don't think I'm adding. I was looking forward to seeing the makeup of the commission. I wondered what minority and representation. Commission. Yeah, they have to drop that in and suggest it. Because that's what I do. Everybody knows me for being an activist, long standing here in this community. So
Yeah.
it's a pleasure. Thank you.
Thank you.
Well, thank you.
Executive director has indicated that you would provide us with information about your financial hardship claim.
I haven't worked since '98. I was an administrator for the state of Kansas. I haven't worked since '98, so I'm well in retirement, Medicare, and
you don't,
I get papers. So all in all, it's about, I don't know, about $3,000. It hasn't hindered me. It hasn't stopped anything. I've still been able to go out in the world and do great things. Right here in the
Okay. Do any commissioners have any questions of Mr. Scroggins? If there are none.
I do actually. You've mentioned you've been a lobbyist since '74?
No, 76.
76, and a lobbyist as in registered and. So
No,
when you say lobbyist, what are you thinking?
This is my first time being registered. Pre-sale revenue. Dr. Ron, William Campbell, and recently with this clause, this now. Yeah. I'm down there pretty much all the time. They know me by face, and I go back to Bennett. I think Bennett is when I started. Yeah, and there was a guy, and then one guy got killed. Well, he killed himself. He was bullied. It touched my heart at that time. I was a young man. I know about bullying, but yeah, that's kind of stuff.
And here he was 13 days late with a $400 fine.
Again, sir, the mail, you have to check that out.
Right. Yeah, I mean, to be candid, the not knowing and didn't receive it. We don't accept those as explanations.
Why is that?
Well, I'm glad to converse with you. I can do it afterward too. But the idea is that everyone will always claim not to know, and everyone will always claim not to have received. So the issue becomes, especially as a lobbyist, required to follow a series of rules, obligations, the disclosures, the transparency. Part of that is also knowing the rules that are involved with filing. And that's the rationale behind it. You can disagree.
No, I don't disagree with that. I just don't have anything to file, and I did not know. Had I known, I mean, I could just come here and know this white guy. And you can see my face here. It's the news. So it was a lot of things going on. One thing is I changed location and I've never received it. And had I received it, then I could have probably should like that. I know what you're saying, but there were some special cases when I challenge you to do. Did not receive it. You know, somebody even opened my mail. By the time I got it, it was open. So, yeah.
Any additional questions, or do any commissioners wish to make a motion with respect to the waiver request?
Mr. Scoggins, if we, cut your fine in half, did you pay the other half of the fine in 30 days?
No. I don't think it's fair and I don't have the money. I mean, I have not worked since '98. I met you over in Lawrence. We have a picture. Lawrence. Sure. I've always given my money back to the community. I don't see why. I haven't worked since '98. I would have wore a suit, maybe they would have helped, but I went to the closet and I'm too fat for all the suits I got. So, there you go. Y'all do what y'all want.
Well, thank you for your attendance and thank you for your comments.
Will I get something in writing and will it be registered again? Because like I say, my mail gets open, so. Sometimes I was playing kind of misses in the area.
Mr. Berger, do you look at the financial hardship declaration? Do you think that has weight and credibility in determining whether or not we need to either waive or find a partial waiver?
So I always find the financial side of things to be important, but I also find the obligations as a lobbyist to be equally important. So with obligations for, you know, the transparency, and I'm glad that there isn't anything in this particular instance that affects the transparency, but the reality is that sometimes these rules seem like they are, that they do not bear much fruit because there's no substance behind what gets disclosed. But
nothing to disclose, sir.
But they are still in place, and as a lobbyist.
But you're talking like I was trying to violate something. You know, like I did it on purpose.
So it indicates a report was received.
It was.
13
And
days.
what does that indicate?
I don't have the report in front of me. My memory is that it would disclose no expenditures.
Nothing received.
Correct.
Was there any between, I don't know when you registered as a lobbyist?
I'm not mistaken, in 73, now my memory's kind of bad, but I think it's, was December, January or something.
Of last year.
2023.
Well, it was spiritual report.
Okay,
And so, okay, since you put it like that, it was January.
so when did you move? So about 12 months after you had registered?
No,
Before?
I moved in December. I applied in January.
You applied in January of this year or 2022?
I mean, she looked like the lawyer right there, she looked like she had done her homework. She basically done it all, so, yeah. In this January.
Yeah. Okay.
That's a question, Caitlin.
To me, yes.
Yeah, this is probably just a novice question since I'm brand new and it's my first meeting, so pardon me.
No.
So I'm just looking at the one right before Mr. Scoggins in our binder and then the one right after. And it looks like all three were sent a notice about a report having been due on February 10th. And then it looks like all three eventually did file reports.
Do you think my response to
That's correct.
both?
Yeah, I've got that here, Mr. Scoggins.
Yes.
Okay, so my only question is that A, is that correct? And B, those were 600 and this one is 400. Is there any explanation for that? I was just curious.
It's the calculation is the amount of how late it is the statute does, I can't remember the exact calculation, but it's a certain amount per day. And these are all lobbyist reports, which is why they have that February 10th deadline. That's a little off. It's different from the campaign finance reports.
Okay, thank you.
After the failure to file is sent, there's a 2-day grace period.
Thank
The
you.
first day after that is $100, then $50 a day, every day up to a maximum of $1,000.
Got it. Okay.
Do any commissioners wish to make a motion? Because if there are none, we are going to move on.
I would move that, if a payment of $100 is made within 30 days, the remainder of the fine be waived.
Thank you, Jerry. Does any commissioners wish to second that motion?
I'll second the motion.
Thank you, John. Is there any additional discussion? We'll take a vote on the motion. All in favor of the motion to provide a partial waiver on the conditions that if 100 is paid within 30 days, the remainder is waived. All in favor, signify by saying aye and raise your hand if you might. All opposed say nay. The motion passes.
Nick, I'm sorry. I had to refrain from voting because my computer crashed and I missed a significant portion of the discussion.
Oh, yeah.
Okay, so I'm not.
That's fair. That's fair. Thank you, Commissioner Schonifer. All right. So the motion passes. We will move on to the next, and I guess we'll go back to the top, Mr. Skoglund. And
Sure,
Mr.
yeah.
Scoggins, you are welcome to stay or to leave, your choice.
Well, I'm kind of like stay.
Okay.
Yeah,
All right,
that
so-
was that.
Returning to the agenda, we have a Patrick Baker.
Might not have it looks really bad not to have the minority representation on commissions and boards. I'm sure y'all look around and stuff and say, well, where are the minority representation? That's only fair and reasonable. I'd like to say that and take my exit and I'll be back. Will I get notification of the next meeting? Because David's right down the street, I'm down there all the time. You come on up here too.
We'll talk about it for sure. Not a problem at all.
Okay.
The next one is Mr. Patrick Baker, who's a lobbyist.
Thank you.
All but one of the waiver requests we have today are for lobbyists, which is pretty typical for around this time of year. They assert unique circumstances. The unique circumstances they assert are primarily inactivity, zero expenditures, and issues with emails. Those are not categories for good cause. I would encourage rejecting this waiver request.
Baker?
Baker, yes. It's a $600.
Are there any questions, any comments, any motions? If not, we will move on.
The next is Christopher Chastain, who is a lobbyist, assessed $550, asserts two rationales. The first is medical, the second is financial hardship. I would actually encourage rejecting the medical claim. The lobbyist does not provide medical supplemental information. He simply indicates that he was sick at the end of January. The report was due on the 10th, and actually, since that was a weekend, we didn't send failure to files out until the 13th. That was quite a bit of time before failure to file notices were sent to submit it at some point in that time frame, plus another 2 days of a grace period. So I would encourage, if this is granted for any basis, I would encourage it not to be based on medical. However, the hardship you have there as well. Again, I'll note payment plans can be options as well, but I will not weigh in on hardship, at least until I get a better feel for how the commission views the factors on hardship.
Any questions, any comments? Commissioner Helmer, do you put weight in the financial hardship declaration?
In individualized cases, yes.
Commissioner Glenn, do you find the financial hardship declaration credible? Do you give that weight?
Can't quite read what he says under other pertinent financial information. I have three, total?
Employers, I believe.
Employers, okay. It looks credible.
Do any commissioners wish to make a motion? If not, we will move on.
The next is Shelia Davis. She actually originally requested a waiver back in November. The commission was, I think, right about to reject it and then determined that, maybe this was January.
Yes.
But the commission determined that because she's primarily asserting a hardship claim, the commission wanted to give her the opportunity to resubmit with using the hardship declaration, and she has done so. You have that attached there. I'm not going to weigh in on hardship.
So the 1,000 is really long. She just didn't.
She was assessed the maximum $1,000 for a late report, and she was assessed back in November.
Yes, and this was a candidate, not a lobbyist, which is why the report due date is different.
Yes.
And going back to my admittedly ignorant question earlier, the higher fine basically reflects a greater period of time in terms of the deadline that was.
Correct, and I believe this is the maximum.
Yes, she reached the maximum, which is actually why you see the report was received on December 26th, and she was actually assessed before that because she had reached the maximum already, and we do the assessment when she reaches the maximum. Otherwise, it would happen when the report is received.
Got it.
Questions, comments, motions?
There, I find this financial hardship statement credible, qualifies for SSI. In that regard, I would move that we waive the assessed fine.
I can't hear it.
We can't hear.
I would move we waive the fine based upon the financial hardship.
That's the motion. Do any commissioners wish to second it?
I'll second it.
Thank you, John. Any additional discussion? If not, we will take a vote. All in favor of providing a complete waiver based on financial hardship, signify by saying aye and raise your hand.
Aye.
All opposed say nay.
Nay.
So we have one lone nay vote. The motion passes. We will return. Go ahead.
I'm sorry. The next is Mr. Kevin Gregg, a lobbyist who is assessed $200 per client for $600 total. He is a lobbyist for 3 clients and was assessed for each. He attached a document to provide a lengthier explanation than the space permits. I would encourage you to read that as well. I do not recommend the waiver. The being no longer employed with an organization is actually specifically identified, I believe, on this form as a reason that does not provide an adequate basis for a waiver. Second, we actually attached some supplemental information. Our lobbyist coordinator, Jessica White, sent an email on the due date, January 10th, to Mr. Gregg's personal email. He replied on January 10th, indicating he needed his username and password. Ms. White provided the information he needed to obtain that access. Nonetheless, he still did not file for another week. You have the email chain there for you. So even if the commission were to consider the waiver on a unique circumstance, based on that email chain, I would encourage denying the waiver.
Questions, comments, or motions? If not, we will move on.
Next is Mr. Robert Maines, lobbyist, was assessed $200 for the January report. The additional explanation looks like it wrapped oddly. You have an attached page that has the full explanation that wraps properly, starting with my registration and reporting and ending with received the late notice. He asserts that basically inactivity, 0 expenditures, and other employees leaving, his assistant did his reports for him and then left. Those are not typically categories for good cause. I would encourage, again, not granting the waiver.
Questions, comments, or motions from commissioners? Hearing none, we'll move on.
We have also fixed the form to where that wraparound issue doesn't happen anymore, to be clear.
I see.
Since it was, yes, so that will not be a problem in the future.
David Schneider, a lobbyist who was assessed $600. He asserts financial hardship. He attached the financial hardship declaration that you have in front of you. I, again, have no recommendation on hardship declarations.
What's the penalty for lobbying without being registered?
It is a misdemeanor. I don't recall which level it is. It's probably Class C because most things we deal with are Class C misdemeanors. But it is a violation of our laws that we can assess fines for. It's also a, I'm fairly confident that is a crime as well. Most of our violations are crimes.
So we have a
yes.
$600 assessment.
Yes.
Any questions, comments? Do any commissioners wish to make a motion? Commissioner Berger, do you find the financial hardship declaration in this instance credible, compelling?
I don't disbelieve what he has to say. But as is becoming apparent, my sympathy toward lobbyists who can't follow rules is low.
Do we know if there's any prosecution pending?
I'm sorry?
Do we know if there's any prosecution pending?
For Mr. Schneider?
Yes, you were saying.
I'm
that it's a
unaware.
Didn't know whether
That would
anything had been filed.
That question was in regards to lobbying without being registered, which is
He is registered.
right. Yes, that's not the issue we have in front of us. This issue is someone who is a registered lobbyist who filed a report late.
All right, okay.
Yes.
Commissioner Dingler, Patty, do you find the financial hardship declaration compelling, or do you put any weight in it?
I don't think I have enough information to do so.
Do any commissioners wish to make a motion? Last call. If not, we will move on.
Remember, we already addressed Mr. Scroggins, so now we're on the last one, Mr. Jason Wagner, a lobbyist who is assessed $600. He asserts unique circumstances. He outlines that he is a first-time lobbyist. He did not have any, he believes he did not have any expenditures and thought he only needed to issue a report if he had spent money. Those are not categories of good cause. Additionally, our lobbyist coordinator sends many reminders that are very clear regarding deadlines and what must be filed. And if you are going to be inactive, it also spells out the alternative that you file an affidavit, which was not filed in this instance either. So again, I would recommend not granting the waiver.
Questions, comments, or do any commissioners wish to make a motion of any kind? Hearing none, we will move on.
I will say this is the end of the civil penalty waiver request, but I had just had a quick comment. I will note that we obviously denied many more waiver requests than we previously did before the guidance document. I do think that this is very consistent, and the guidance that the subcommittee and ultimately the commission fully provided here allowed for clear guidance. And I think I appreciate all of the work that was done to bring us to this point. So thank you.
Yeah, and I guess from my perspective, and I think particularly for Commissioner Glenn and Commissioner Jackson, just so you understand the background here, we did not previously have a form of this kind. And so it's really only been in the past year that this form has come to fruition. In fact, this meeting, I would say, is the first time that we've really seen the majority of our waiver requests reflected in this form. So I think my big takeaway is I see that these are largely based on financial hardship. So one of the questions that I think we all need to continue to ask ourselves is, what do we find material in terms of financial hardship for purposes of granting a waiver request in the future? And I'll think about that. I think every commissioner should think about that, because I think it is for the good of the commission if we can determine with some consistency what that threshold level looks like. And again, there are a number of factors, but I think just generally speaking, I think we should try to understand what we find material. The next item we have on the agenda is the civil fine hearing. Do we have Mr. Hamblin in attendance?
We are double checking up front. Real quick. Making sure, no stragglers. Okay. No? Okay. No, we do not have Mr. Hamlin.
So without Mr. Hamlin in attendance, I believe we will still proceed with the hearing, and Patty has agreed to be the hearing officer in this instance. Is that still your understanding, Commissioner Dengler?
Complete with the gavel.
So before we begin, I will also just say, just for Commissioner Glenn and Commissioner Jackson, previously Commissioner Solbach had often had the honors of being and serving as the hearing officer. I think we're going forward looking to have more of a rotation of commissioners taking turns in different matters, serving as hearing officers. And as we do that, I think we're also trying to really solidify the procedures that we follow. And so this is a learning process for all of us, but Patty, I'll hand it over to you.
Yeah, Mr. Chairman, the hearing officer does have to be an attorney.
Okay.
I'm exempt.
Jay, correct me if I'm wrong. I don't believe that's true under CAPA.
Oh, it isn't?
It's typically an agency head or
Excuse
someone
me?
designated.
I'm sorry.
There's a presiding officer who's designated by the commission. So
Okay.
Yeah, they don't have to be an attorney under the new law that applies to us. Yeah.
All right, if everyone's ready, we will proceed. My name is Patricia Dengler. I have been appointed as the presiding hearing officer today. And the complaint is Mark Skoglund, Executive Director, Kansas Governmental Ethics Commission complainant versus Scott Hamblin, candidate for City Council respondent. Complaint number 755. The hearing's called to order. Would the parties announce?
Yes, I am Caitlin Bull-Stewart, appearing on behalf of the Executive Director, Mark Skoglund. Mark Skoglund also appears.
Thank you. And with respect to the respondent, do we have an announcement for purposes of this hearing?
Respondent does not appear.
And we understand that this is a complaint before this commission. It is going to be conducted according to the provisions of the Kansas Administrative Procedure Act. The applicable burden of proof is that affirmative findings of fact by the commission shall be based on clear and convincing evidence. Since it is being recorded, I ask that any responses to questions be verbal, since audio and video will not pick all of those up. And also that people do not speak over each other, so that it makes the recording that much easier to understand. With the fact that the respondent is not present and will not be participating, this matter can proceed by default. However, there are still some certain procedures that we have to follow through.
You can proceed with offer.
I know. I'm not sure that there's any need to make an opening statement, but certainly there is that opportunity.
May I keep it brief, Commissioner?
You may.
As far as campaign finance violations go, this is a fairly cut and dry matter. This is another instance of a candidate that had failed to file reports that were required under the Campaign Finance Act. Mr. Hamblin was a candidate in the Overland Park 2023 City Council election, and this complaint and hearing today regards his failure to file his July 24th, 2023 receipts and expenditure report. As we've discussed today, the filing of such reports are critical so that the public has access to information relevant to elections, and our agency is tasked with ensuring such reports are filed and available. I will be offering, upon the presiding officer's permission, the executive director's evidence of a violation through a proffer.
Okay, very well. Even with this proffer, and especially for the benefit of those who are new today, commissioners do have the opportunity to ask questions. However, the procedure has been is that you wait until the evidence has been presented and that has been concluded, and then questions can be asked if necessary. So if you want to proceed with the proffer.
Yes, absolutely. As a candidate for office under the Campaign Finance Act, Mr. Hamblin had subjected himself to the jurisdiction of the commission. As the commission is the sole state agency that is charged of enforcing at least the civil aspect of the Campaign Finance Act. Service was proper and was made to Mr. Hamblin at his home address as it was listed on his candidate's declaration of intention filing form, which was included with some of the probable cause and the administrative record materials that you all have. Mr. Hamblin had a legal obligation to file, and he did not do so. Mr. Hamblin functioned as the treasurer for his own campaign, and treasurers for campaigns are required by law to file receipts and expenditure reports at various times in an election cycle, including the 8th day preceding the primary election, which was what was occurring here. That's pursuant to KSA 254148. Additionally, the commission was required under KSA 254152 to send a failure to file notice via certified mail to any person failing to file the reports required by 254148, notifying them of their obligation to file. Commission staff did that. They sent the failure to file notice via certified mail, and Jennifer Schneider, the head of our local campaign finance desk, followed up with Mr. Hamblin via email and gave him actual notice and received responses from Mr. Hamblin indicating that he understood his obligation to file and that his report was late. In the context of this commission's burden of proof, as the presiding member has established, it is by clear, there have to be affirmative findings of fact, and to find liability, it is by clear and convincing evidence pursuant to KAR 1974. And the Kansas Supreme Court has stated in Re BDY that what clear and convincing evidence is not a level of proof higher than preponderance of the evidence, but is about the better quality of the evidence required to satisfy the preponderance standard. Here, there's not much of a factual dispute. It's rather a question of law. Mr. Hamblin was required to file. He did not do so, and the report has still not been filed today. Mr. Hamblin's candidate's declaration of intention filing form was filed May 26, 2023, which subjected him to the commission's jurisdiction and the campaign finance laws. Commission staff, as I mentioned, provided him with notice of failure to file his report on July 2nd. And the report has still not been filed. At this time, I would like to swear the complainant in with the permission of the presiding member for his testimony regarding the outstanding report. Do I have your permission?
Yes, you do. Okay, Commissioner.
You do solemnly swear, sincerely and truly declare and affirm that the testimony you shall give in this matter at issue shall be the truth, the whole truth, and nothing but the truth, and this you do under the pains and penalties of perjury.
I do.
Let me pull the complaint out. Do you have a copy of the, you do, perfect. Excellent. So we're just going to walk through the allegations of the complaint to ensure the same is true today. Do you understand?
Yes.
Scott Hamblin was a candidate for city council in the 2023 election cycle and served as his own treasurer. Is that correct?
Yes.
Oh, could you please, for the record, identify yourself?
Mark Skoglund, Executive Director of the Kansas Governmental Ethics Commission and complainant in this matter.
I will restart from the top. Mr. Hamblin was a candidate for city council in the 2023 election cycle and served as his own treasurer.
Yes.
And on July 26th, the commission sent notice via certified mail to Mr. Hamblin notifying him of the requirement to file the July report.
Yes.
Finally, the notice informed Mr. Hamblin that he had until July 28th to file the report to avoid a civil penalty being assessed.
Yes.
And Mr. Hamblin, has he filed any reports that you know of?
No.
The final question I have for you is, are there other outstanding reports that Mr. Hamblin owes?
Yes.
What are those reports?
It's my understanding that he has not filed any reports after this time.
So what are the two? Would that be October?
I believe October 2023 and January 2024.
Okay. Thank you. You may
Thanks.
remain seated. Additionally, Mr. Hamblin has been assessed outside of the issue today of failing to file the July report. Mr. Hamblin has been assessed by the commission once before In complaint number 696, where the commission found Mr. Hamblin twice violated the Campaign Finance Act, once for failure to file the July 26, 2020 receipts and expenditure report, and once for the prohibited use of campaign funds pursuant to KSA 254157A. Mr. Hamblin paid the fines that were associated with that prior matter. $5,000, and this is significant as I will get to in a moment, $5,000 of that fine was attributable to Mr. Hamblin's failure to file the July 2020 report. Mr. Hamblin additionally, as was mentioned by the witness, Executive Director Skoglund, also has an outstanding report for October 2023 and January 2024. Our hope was to secure compliance, so these reports would be filed without the need for a complaint.
Anything further?
I am ready to proceed to closing statements unless commissioners have questions.
Sure, Mr. Bowman, witness, but the other information that you gave, if you had the actual witnesses to those things, that's what they would testify to, and that's what you're proffering to the commission.
Yes, Commissioner Silva.
Okay.
You put that more directly. Executive Director, you testified to the best of your knowledge that they hadn't filed the report. Did he file his report or did he not file his report?
He did not file his report.
Are there any other questions?
May I proceed to closing?
Yes, I wanted to make sure.
Oh, I
I was looking at Mark to see if he had anything, so. Seeing that there are none, do you want to proceed?
Yes, please. As I mentioned before, this is a clear-cut matter. Failure to file when obligated to do so. Staff went above and beyond to communicate with Mr. Hamblin, but have not secured compliance. The fine is appropriate here, and even under this higher standard of proof, he would still be found liable because the only evidence here, in addition to fulfilling staff's notice requirements, is that Mr. Hamblin has not filed the required report. Furthermore, Mr. Hamblin was not deterred from failing to file his required reports by the $5,000 fine that was previously imposed by the commission under complaint number 696. Therefore, the executive director recommends a fine amount of $10,000 to be imposed on Mr. Hamblin. Further, if the commission chooses to offer a reduction in fine in exchange, the executive director asks for, in exchange for the reduced amount of the fine, that any reduction be conditioned on the filing of all outstanding reports, the July 2023 report, the October 2023 report, and the January 2024 report. If Mr. Hamblin does not file all of his outstanding reports to comply, then the executive director requests that $10,000 fine because if found liable, this would be the second time that the commission has found Mr. Hamblin has violated the Campaign Finance Act.
So what would be the fine if he does? Or no, if he doesn't. It's the 10,000 if he doesn't, and then 5,000 if he does?
We are requesting $10,000 as the fine to be imposed, but if the commission so chooses,
Oh, if we so
in their
choose,
discretion,
that's what I didn't understand.
we request that a reduction in the amount be conditioned on filing all of the
And
outstanding.
we would have to set that amount.
Correct.
Okay, got it.
Mr. Chairman, I would move that we impose that we find Mr. Find this gentleman has violated the Campaign Finance Act, impose a $10,000 fine. If he files all of his reports and pays it within 30 days, the fine will be reduced to $7,500.
For point of clarification, I would prefer that we address the issue of whether or not there's a violation upon the determination by the commission. At that point, then we move to the assessment of any fine.
Okay.
That would be the proper step for us to go into deliberations.
Then I would move that we find the violation.
May I also introduce findings and conclusions?
I was gonna ask if you had those.
Yes.
Okay.
I have proposed findings of fact and conclusions of law that I prepared for the commission's approval. For those of you that are online, I have dropped it into the open session hearing exhibits meeting materials. You'll just need to update that. Paige is passing out the hard copy for everyone here in the room. I have drafted this for the commission's approval, either as is, I mean, it's not going to be as is because there are blanks to be filled in. We can fill in the fine amounts, we can make amendments to the findings and conclusions. But this is, I feel like would help the discussion regarding liability and regarding the fine amount.
Madam Chairman, I would redo my motion by adopting the findings and conclusions that we handled.
May I ask a question before we get to the vote?
Yes.
Okay, Caitlin, I heard you say that he was undeterred in filing, and I understand your argument, but did we receive evidence on that? In other words, did you ask that question of Mr. Scoglin?
I did not ask that question of Mr. Scopeland.
Is that an important fact that needed to be proved?
No, I would consider that just, again, a question, not necessarily a fact question, just he did or he did not do it. So that it was more of a policy argument.
That's kind of what I was thinking, that maybe that could be something that if he had showed up and we'd received other than undisputed evidence that he might have wanted to use as a defense. But you did make the argument. I wanted to know whether that was something you had to prove, because I didn't think we received any evidence on that.
Correct. Yes, that was a policy argument.
All right.
Thank you.
Very well.
Asking.
Yeah.
I would note that the conclusions that we've been handed, it has a blank for fine, and we're leaving that blank there because we'll deal with the fine with a second motion. So, yeah.
Yes.
And so the relevancy of the military service is just to make sure it wasn't deployed or something? Is that what you're?
That is because under the Service Member Civils Relief Act, even administrative matters, you have to determine before granting default judgment if the individual is in the active duty military. Or
Okay, so that's what you're doing.
Mm-hmm. That affidavit is also, we have hard copies on file. I put that affidavit in the hearing exhibit.
No, I
as well.
thought that.
Mhm.
I don't know if this is a timely question, but what's the commission's practice or authority to seek to go to collections if there's a penalty imposed and the person just doesn't pay it?
Yes, so the commission uses largely the Kansas Debt Recovery Set-Off Program. I'm not getting the name exactly right, but essentially we send our collections to it's another state agency that diverts funds from individuals' tax returns or any other money that they're owed to the state.
Got it.
It's been very limited if we've ever sent anything to collections,
Yes, we do have that option, but we haven't
which
used
would
it.
be to a firm to
Mhm.
collect the debt.
Right,
Not something that we're generally done. with.
understood.
Mhm.
The basis for my question is just kind of given the history here. I wonder if
Yes.
he's just gonna blow it off.
These are
Mhm.
so.
Mhm. Yes.
I made my motion,
So that can't.
Oh, yes. The other thing to note too is that it also creates a remedy in that he cannot run for office with outstanding reports and an outstanding fine.
Mr. Solbach has a motion, I'll second.
Okay. Patty, we've got a second.
Is that to adopt these?
Yes, as far as this particular proceeding, we have the option of deliberating in public or deliberating with our conflict counsel with the exclusion of
Mhm.
the general counsel and the witness and others, with the fact that this commission order proposed findings and conclusions have been submitted to us, we can elect to deliberate here. We've already had some of those discussions. In addition, there are some findings that need to be made concerning the fact that this respondent did not appear. So findings with respect to default and including notification for that.
I believe those findings are included in the version that we've provided to you all.
Okay.
But thank you.
Yes, thank you.
And I think for purposes of this hearing, whether or not people have had the opportunity to review this to fully adopt it and incorporate it as the order. Since it has been, yes, I understand that there has been a motion and a second. Fine violation. Pursuant to the finding of fact and conclusions of law.
Then our proof of service.
We can walk through that. What are you asking about being served?
Whether or not he was served with regard to this particular proceeding.
So several things regarding service, regarding Mr. Hamblin. The original complaint, he received notice of. He signed for the certified mail for the original complaint. For the original notice of hearing, he also signed the certified mail for the original notice of hearing. Whenever we moved the hearing date the first time, because it was originally supposed to be in January, Mr. Hamlin was sent an email and responded, indicating that he understood in response to the motion to continue. We have sent him certified mail every time that it has been moved. Certified mail has come back that he has never signed it, but the first class mail has never been returned. It is in fact his residential address. According to the property records that I've reviewed within that county, that is his residential address. I have called him every single time before the meeting and sent an email letting him know. So we have done everything that we could to provide him notice. We do have confirmation that he received actual notice of the February scheduled meeting. And he has just no longer been responding to us, but we do know that that is the way he had received actual service before, and these were the correct addresses.
You mentioned the complaint. How about the First Amendment complaint? Was that served on him?
The First Amendment complaint was served on him, but he did not sign for the certified mail. The first class mail did not come back. Our statute only requires that a service of an original complaint be via certified mail. And I will add the amendment was only a change in language in the attached affidavit. It was not a change in the substance of the allegations.
Any other questions or comments? We can proceed to finalize this. So all those in favor of finding one in default and
Can I request the commission adopt the findings and conclusions as they are written with the fine amounts to be filled in?
That was my motion.
Okay, sorry, just clarifying.
proceeding with that.
Okay,
First one is to find that the respondent, Scott Hamblin, is in default. All those in favor?
Aye.
Aye.
Moving on, then the next point to consider is based upon the proffer of the evidence and the further discussions, information. Do we find that the respondent, Scott Hamlin, has violated the Campaign Finance Act as alleged in the amended?
Aye.
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 Given that, then we are adopting the proposed findings and conclusions. The next point that we go to is with respect to a civil fine.
I would move we fine him $10,000, and if he files all his reports and pays it within 30 days, then the fine will be reduced to $7,500.
I'll second it.
Excuse me?
I'll second it.
Okay.
Any further comments or questions? Considering.
Well, sorry, just in comment, I know that he's a difficult partner with the office as far as his obligations go. And I know it's within the authority. And $7,500, we just agonized over $100 for one individual. And we're kind of cavaliering saying $7,500, which is a pretty serious now barrier to entry for his being allowed to run for office again. And that, like I say, I don't know if that's a good or a bad thing, but that feels very heavy to me as an amount. I'd be more in line. I know it was $5,000 before, but that was in 2021. And I would just be opposed to it in the amount.
Okay.
I understand.
I have the same reservations.
Go ahead, Mark.
Thank you. I kind of have the same reservations. On the one hand, maybe it's a good deterrence, you know, if he's not able to comply with the filing requirements that he's supposed to, you know, doing. Maybe he shouldn't be sitting in office. I don't know. But I feel the same way. That's a big fine. And so, especially for non-filing. So I just, I don't think that I could vote yay on that one.
I hear the arguments at the fine level. However, his behavior is such that it's intentional and consistently intentional, and in some ways defiant. He certainly has a right to ask for relief of our fine assessment if he chooses, and we can revisit that at that point.
Any further comments?
And I get that. I get that, you know, the compliance is a problem, but I mean, most of my practice is in criminal law, and I don't see $10,000 fines for a lot of felony convictions that are much more egregious than this. And I think, Judge, you could agree that that's the truth.
I've never assessed a fine in a felony case except in a fine. So it's very rare.
My point. That's my point.
Clarification, Chris, is your concern more with the 10,000 or the alternative 7,500 if he pays it within 30 days?
Beginning with the 10,000.
Okay.
So the reduction to 7,500 is kind of a meaningless reduction to me.
Well, it's $2,500 if he steps up to the plate.
It's incentive to get him to do it. Yeah.
I can do that.
That's what I was thinking.
Any further discussion? Okay, we can take a vote, and I think it would be easier if we vote by a show of hands, since we have to go by a majority of the commission. So all those in favor, raise your right hand. Six. All those opposed? Two.
I can't tell what Nick's doing.
Oh,
I couldn't tell what Nick was doing either.
It's off camera.
Thank you, Nick.
They've got 3-point signal in the NC2A tournament.
If I just might clarify for the sake of the transcript, I think it was 5 in favor,
Was it 5? Okay.
because I think the chair was a vote in opposition.
Yes, that's correct.
So I think it's 5-3.
5-3, okay.
5-3. Okay.
I would like to offer an alternative motion that is similar, but with a reduction to 2,500 as opposed to 7,500 if all reports are filed within 30 days.
And the lower amount is paid?
Correct.
I would second that.
Procedurally, could I clarify?
Yeah.
So this would be in the motion is to replace the fine that was just passed. Is that correct?
But it passed.
It did
It
pass.
did.
Yeah, it did pass.
Mm-hmm.
So I'm unsure on procedure.
Supersede.
This is a superseding motion.
That's fine.
I think it's appropriate.
I'm not objecting one way or the other. I'm just
Trying to
make sure-
understand.
Making sure that we.
Making sure we all
Okay.
understand.
Yeah.
Yeah, we didn't have any recommendation as to what the reduction would be, so.
So Nick, you're saying 10 reduction to 2,500 if all reports are filed?
And the
And the lower
lower.
amount.
Okay.
Really good incentive.
Correct. And
Right, yeah, and pay the 25.
Within a 30-day time frame.
yes.
Yeah, I think it's good.
I like that approach as well. I still just have a problem with $10,000.
We need to, you want to second it?
No.
I already seconded it.
Or just second?
Commissioner
30 seconds.
Schonifer already seconded.
So it's been moved and seconded to consider superseding decision with respect to the civil fine. So the assessment would be for $10,000, but reduced $2,500 if within 30 days, all past due reports and fines are paid.
Yes.
And with the fact that there were some on the agenda today that were assessed.
Those were civil penalties.
Okay.
Yes, they're separate.
Separate and apart.
Mhm.
That's what I was about to clarify, is that it's civil
Okay.
penalties are not part of this,
Mhm.
Okay,
part of the motion as indicated.
Yes,
okay.
thank you for asking.
So, let's vote. All those in favor?
Aye.
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 6.
So here's just one nay.
Okay, well, no, I didn't see.
Two
2
nays.
Jerry. 7-2. So with that vote, that supersedes the earlier one.
Mhm.
So the amount will be the $10,000 civil fine is imposed. And if the respondent, Scott Hamlin, pays it within 30 days and brings all reports up to date, then it will be reduced to 2,500 at that time.
I will amend that language before sending to Nick. Okay.
Okay, there's nothing further to,
We have one more motion.
what, oh, for the,
For the convenience of the commission, if someone wanted to move to allow the writing officer, Patricia Dangler, to produce and sign this order.
So moved.
Seconded.
I've been on that horn before.
all those in favor?
Aye.
Any opposition? Nick opposed it, okay.
And I will rephrase,
And a
I will
chair.
amend the language before I send it to
There's a
Commissioner
lag.
Dangler for signature. Oh. There might be.
There is, yeah, there is.
There
There's
is,
a lag.
yes.
Oh, wow, that's crazy.
All right.
Okay.
March
then
Madness.
we'll
Can we fix that?
close that part of it. And I'll turn the meeting back over to Mr. Hale as chairperson of the commission.
Thank you, Commissioner Dangler. The next item we have on the agenda is executive session. And I believe we have that before recess session. Director Skoglund, how much time should we reserve for executive session?
I don't think very much. I don't think you have the materials, so.
Yes. Sorry.
Before we jump into that, one more thing to follow up with Hamlin's
Absolutely.
matter. Mr. Chairman, we can make consideration on whether or not we will vote to recommend further action be taken by the appropriate prosecutor for any criminal liability associated with violations found today with the order.
It'll automatically be sent.
That's part of the procedure that we have.
That's
For
true.
purposes of the individuals who are new to the.
We can make a recommendation or no recommendation,
Right.
but it'll be sent to the prosecuting authority regardless.
And our order concludes with that.
Mhm.
Noted. So are we good to move on? Any
Yes.
other comments? Okay. So with, I have 237 right now. Do we want to say 245, 250?
It's really up to you. I think that there's not a lot to discuss in this, but if you all have questions, then, I mean, you know what the materials are. So I would think no more than 10 minutes for this matter. But
Let's
if you
just
have
say-
a bunch of questions, then.
Let's say 250.
Okay, great.
And
If there's
can
more,
any
we can
commission-
revisit.
can any commissioners, in your materials, you have the motion as it's written for executive session. Can I get any volunteer to read that motion into the record?
Go ahead, Chris.
Commissioner Berger, do you have the motion in front of you?
May I?
Go.
You've been drafted.
Mr. Solbach, yes, sir. I move that the commission recess this open meeting to executive session with office manager and anniversary Paige Quintana Paget, executive director Mark Skolin, general counsel Caitlin Bull-Stewart, conflict counsel Jay Rodriguez present, to discuss matters related to potential litigation and for good cause as provided by KAR 19-6-2. Justification for executive session is so the commission can consult with its attorney regarding matters that would be deemed privileged in the attorney-client relationship as contemplated by cited statute. the open meeting shall be resumed here at 2:50.
Do I have a second? The motion has been seconded. Any additional discussion? Hearing none, all in favor of approving the motion signify by saying aye.
Aye.
Mark is back on.
Yeah.
Oh, we did get? No.
No, he's not.
No, he's not.
Oh, okay.
False hope.
Oh.
Yeah.
Gotta be kidding me.
Another technical problem.
There it
we go.
is.
There,
Excellent.
we are live.
All righty. Now we can do things.
Commissioner Helmer, I believe you were about to make a motion.
I move that the commission ratifies decision made in open session at the March 7, 2024 special meeting to adopt the findings of fact and conclusion of law attached to the application as amended for subpoenas 2024-01 and 2024-02 and issue subpoenas as amended to 2024-01 and 2024-02.
Do I have a second?
I'll second.
Thank you, Patty. Any additional discussion? Hearing none, all in favor of approving the motion to ratify signify by saying aye.
Aye.
All opposed say nay. The motion passes. Returning to open session, we next have recess session. And again, Director Skoglund, can you give us an estimate of the time that we're going to need?
There is obviously a lot. I would think at least 45 minutes, but you've all seen the materials. Longer than that may be well justified for even the first attempt at this. Just remember, any time that's part of the motion, we can't reconvene to open session until after you. So if you say an hour and you take 30 minutes, you're in there for another 30. But I don't think there's much risk of using less time.
Can
I
we
would say at
say,
least 45 minutes.
let's just say 3:30. Let's say 3:30. Does that sound okay to all the commissioners? Okay. Can someone do me the honor of reading the recess motion?
I move that the commission recess before the meeting, conflict counsel Jay Rodriguez present to discuss matters related to confidential investigations pursuant to KSA 25-4165 and KSA 25-4161, and for good cause as provided by KAR 19-6-2. Justification for recess is so the commission can exercise quasi judicial functions from deliberating matters relating to said confidential investigations as contemplated by KSA 75-4318 sub G sub 1. The open meeting shall be resumed here at 3:25.
3:30 is.
3:30.
If not, it's reset. Is this in the new binder?
Yeah.
Thank you. Do I have a second?
This is
Second.
Motion has been seconded. Any additional discussion?
Kansas is our heart's always been in the heartland. They're putting so spooky, dude.
Where do you think this is from, Texas?
These?
It's very similar.
We're being deceived.
Frankly, people are nicer. They're nicer here.
Normal. I don't know.
Normal. NORMAL.
Illinois State University.
Okay, we are live.
It's right in the middle of this.
Mr. Hale, Commissioner, Chairman Hale, there we go. I'll get you. I'd like to make a motion that we have a finding of sufficiency for matters 769 and 770.
Thank you, Commissioner Berger. Do I have a second?
Second.
Thank you, John. Any additional discussion? All in favor of approving the motion to find sufficiency with respect to complaints 769 and 770 signify by saying aye.
Aye.
All opposed say nay. The motion passes.
Thank you, Chairman. I'd also like to make a motion for a finding of probable cause with regard to items 761, 766, and 767.
Thank you. Do I have a second?
Second.
Thank you, John. Any additional discussion? Hearing none, all in favor of approving a motion to find probable cause in those three matters signify by saying aye.
Aye.
All opposed say nay. The motion passes.
And Chairman, I'd like to move to dismiss item 768.
Do I have a second?
Thank you.
Second.
Thank you, John. Any additional discussion? All in favor of approving the motion to dismiss complaint 768 signify by saying aye.
Aye.
All opposed say nay. The motion passes. Any additional motions?
I don't think there's any additional motion, but does the chair have comment?
We wish to, I guess, communicate that the commission would like to revisit complaints 750, 753, 754, and 760 in our next month's meeting. And we would also just like to respectfully request that, given the volume of materials, that they be organized in a fashion that is conducive to quick review. And I think that whether as separate files or whether as bookmarked PDFs, I think could be helpful. Binder view, for instance. So again, I don't know this is anything that requires an action of the commission, but I think it addresses the matters that were raised.
We definitely appreciate that. Is that for all 4 of the items that you mentioned?
Correct.
Got it. We can do that.
And Chairman, if we have probable cause found on 761, 66, and 67, I believe the next step is hearing officers to set them for hearing.
Yeah, is the thought there that we want to set one hearing officer in all 3 matters for one meeting, perhaps the next meeting? Is it?
It would be set for the next meeting, but it's up to you whether you'd like to set multiple hearing officers or just one.
Do we have volunteers? Again, this is something where we are, I think, trying to abide by new rules. I think we're wanting to set a new standard on the way that we conduct hearings. And I know Commissioner Helmer has conducted one hearing with the new rules in place. And Commissioner Dangler did us the honors of conducting a hearing with the new rules in place. Commissioner Berger, if you don't mind, I think that you, with the diligence that you bring to the commission and your thoughtfulness, I would ask that you serve as hearing officer in these 3 matters, again, as we're trying to reset the format on the way we do these.
I'll be glad to try.
Okay. Well, are there any other items that we need to discuss? If there are none, yeah, I will note that the next meeting will occur 4 weeks from now on April 24th. All I need now is a motion to adjourn. There's been a motion. Do I have a second?
Second.
Patty has seconded. Any additional discussion? Hearing none, all in favor of approving the motion to adjourn signify by saying aye.
Aye.
All opposed say nay.